Okay, let's unpack this story. We've got some really fascinating sources here. It reads less like a dry case note and more like a legal thriller, honestly.
It really does. You've got excerpts from a disciplinary tribunal, background summaries.
Hmm.
It paints a picture of a pretty dramatic legal saga.
Absolutely. And there's this stark warning woven through it, isn't there? Especially, I think, for anyone even thinking about a career in law.
Definitely. So our mission today, as I see it, is to really dig into these documents. We need to trace how things escalated, how this highly regarded barrister ended up facing disciplinary action,
Right. Following the procedural steps, getting to know the key people involved.
and ultimately pulling out those big ethical lessons. We're treating it almost like a true crime investigation, but into a professional failure.
Yeah, exploring how ambition, maybe pressure, and a client's really strong conviction all sort of collided.
And what's really interesting, as you flagged earlier, is that the core issue here isn't actually about dishonesty. The tribunal was clear on that.
It's more about control, isn't it? And counsel. Where does giving strong advice cross the line into, well, improper pressure?
Exactly that line. Robust advice versus overbearing the client's will. That's the crux of it.
And what does that mean for, for you listening, if you're making tough decisions, or if you might one day be guiding others?
It's a fundamental question about responsibility in high-stakes situations. Okay, let's dive in.
Let's start with the hook, the opening scene. Imagine this. It's late Sunday night. A big trial starts tomorrow morning.
High pressure already.
And James Lindsay Glissan QC, a really successful, celebrated Queen's Counsel, he goes to his client's house.
Not a typical pre-trial move, perhaps, especially that late at home.
And what happens inside that house isn't just final prep. It's a confrontation. Something happens that shakes everything up: the lawyer-client relationship, the profession itself.
It sets the stage perfectly. So how did it even get to this point? What was the initial spark?
It starts almost mundanely with a neighborhood dispute in Woollahra, Sydney, posh suburb.
Right. Views are everything there.
Exactly. You've got Hart, who's actually a solicitor himself, living next door to Michael Silverman, who's an architect.
Okay.
And Silverman's doing construction work. Hart believes he only okayed some minor alterations, signed off on something small back in October '86.
Standard neighborly thing, signing the back of a plan to show you've seen it.
Right. But then the work starts, and Hart sees something much bigger going up. He looks at the plans actually lodged with the local council, Woollahra Council, and he thinks, hang on, this isn't what I signed. The signature looks like mine, but it's on these much larger plans. He becomes convinced his signature on those council plans, which were lodged by another architect's firm involved, Harold R. Finger and Company.
Right, that name comes up later.
He becomes convinced that signature was forged.
Wow. Okay, forgery. That's not a minor accusation. That's huge.
It's the ignition point. Absolutely. Serious stuff, professionally, personally, for Silverman the architect and Finger.
And Hart doesn't just quietly suspect this, he acts on it.
He does. He's indignant, convinced he's been wronged. He writes complaint letters, not just to the council, but to professional bodies, too, directly accusing Silverman and Finger of forgery and deceit.
So he puts it out there, publicly, professionally. That raises the stakes massively.
Exactly. It's not just a fence dispute anymore. This is an attack on their reputations. So naturally, they retaliate.
So, legally, I assume.
Big time. By 1988, this is blown up. Hart had already started federal court proceedings against a company involved and against Silverman and Finger personally. He's alleging breaches of the Trade Practices Act, Section 52, misleading or deceptive conduct.
Okay, so Hart fired the first legal shot, based on the forgery and deception claims.
Yes, but then comes the counterattack. Silverman, in that same federal court case, files a cross-claim against Hart for defamation based on those public forgery accusations.
Makes sense. Defending his reputation.
And Harold Finger, the other architect whose firm lodged the plans, he doesn't just join the defense. He launches a whole separate defamation lawsuit against Hart in the New South Wales Supreme Court.
Ouch. So Hart is now fighting on multiple fronts. He's the plaintiff trying to prove forgery, and he's the defendant in potentially massive defamation claims.
Exactly. The legal peril for him is suddenly immense. He's gone from trying to get vindication to fighting for his own survival professionally and maybe financially.
And that's the context for bringing in the big guns, like Glissan QC.
Precisely. That intense pressure cooker situation for the client, Hart, is the backdrop for everything that leads to the disciplinary case against his own barrister.
Okay, so our mission, let's restate it. We're taking these sources, the tribunal decision, the summaries, and we're going to trace how this seemingly simple dispute led to a senior barrister being disciplined,
Right. We'll follow the legal steps, meet the key players,
both in the original fight and the disciplinary hearing.
and really try to understand the ethical lessons. It's like that true crime investigation idea, but focused on a professional breakdown. How did ambition, pressure, and this client's unwavering belief just collide?
And critically, as we said, the disciplinary case wasn't about the barrister being dishonest. The tribunal accepted Glissan acted in good faith.
Which makes it even more interesting, ethically. It's about that line, strong advice versus improper pressure, control versus counsel.
Where does one end and the other begin? Especially under extreme stress.
And that question matters way beyond law, right? For anyone listening, if you rely on experts or if you advise others.
What's your responsibility when someone puts their trust, maybe their future, in your hands in a crisis? How do you guide strongly without coercing?
Let's try and untangle that. We should probably start by introducing the main players properly, knowing who is key here.
Good idea. Let's set the stage with the dramatis personae.
Okay, center stage in the disciplinary action, the respondent, is James Lindsay Glissan QC. What do the sources tell us about him?
He's described as a senior Sydney barrister, very well regarded, a celebrated silk known for having a formidable reputation. He was the lead counsel for Ray Hart in that federal court case.
So a big name. His involvement and then the action against him would have definitely made waves.
Absolutely. Then there's his client, the man at the heart of the original dispute, Ray Anthony Paul Hart.
And crucially, he wasn't just any client. He was a solicitor himself, practicing out in Wentworthville.
Right. That adds a layer, doesn't it? A lawyer hiring a lawyer. He presumably understood the process, the stakes, maybe had his own ideas about strategy.
And his motivation. The sources paint him as incredibly determined. He wanted to prove he was the victim of a forgery and wrongdoing, fighting for personal and professional vindication. He really believed he was right.
That conviction seems key. He wasn't going to back down easily, even when things got tough.
And supporting him, literally present at key moments, was his wife, Mrs. Hart.
Yes, she becomes a really important witness later on. She was there during crucial meetings, including that Sunday night one. Her testimony about the pressure her husband was under was vital for the tribunal.
Okay, on the other side of that original fight, the neighbor's Hart accused, Michael Silverman.
The architect next door. Key defendant in Hart's federal court case, the main target of the forgery claims regarding the council plans. And the sources are clear. He strongly denied those claims.
And Harold Finger.
The other architect involved. His firm lodged the disputed plans. He got dragged into Hart's accusations and, as we said, hit back hard with his own separate defamation suit in the Supreme Court. Really upped the ante for Hart.
Okay, now the legal teams. For Hart's federal court case, we know James Glissan QC was lead counsel. Who else was on his team?
He had junior counsel assisting him, a barrister named Peter Strasser. Strasser was at various conferences involved in the prep. His presence and then absence from part of that Sunday meeting becomes relevant later.
And running the case day to day, the solicitor.
That was Ken Creighton Gorley, a partner at Creighton Brown and Crossley. He was coordinating everything, briefing counsel, managing evidence. He also becomes a key witness in the disciplinary hearing, especially about when Glissan found out about certain sensitive issues concerning Hart.
Right, that timing issue. And presumably, Silverman and Finger had their own strong legal teams ready for the fight.
Oh, absolutely. Experienced solicitors and counsel preparing their defense and pushing those defamation claims. They were ready for trial.
Okay, fast forward to the disciplinary proceedings against Glissan. Who are the players there?
Well, the complainant is the New South Wales Bar Association, acting through the Bar Council. They appointed counsel whose name isn't in our sources to prosecute the case.
So like a prosecutor arguing Glissan breached professional standards, not seeking money for Hart, but a ruling on conduct.
Exactly. Their goal was a finding of unsatisfactory professional conduct or professional misconduct.
And defending Glissan?
He was represented by his own counsel, Mr. Coombs. His job was to argue Glissan acted properly, in good faith, doing his duty, and didn't cross that ethical line.
And the judges? Who decided Glissan's fate?
The Legal Profession Disciplinary Tribunal. And the panel was chaired by a very senior figure, Sir Maurice Byers QC, a former Commonwealth Solicitor General. Huge legal heavyweight.
Wow, that lends serious authority.
Definitely. He sat with two other members, Mr. D. Staff and Mr. E. Barnum. Their job was to hear all the evidence, weigh the conflicting stories, apply the rules, and make the final call on Glissan's conduct and any penalty.
So, quite a cast. Neighbors, architects, solicitors, barristers, a QC, his wife, disciplinary bodies, a top-tier tribunal.
It shows how a seemingly localized dispute can draw in so many people and reach the highest levels of professional scrutiny.
Okay, now we know the players. Let's walk through the timeline. How did this unfold step by step? The procedural summary is crucial here, especially those last few days before the trial date.
Agreed. Following the chronology really highlights the mounting pressure and the critical turning points.
So it starts back in October 1986. Hart visits Silverman's house, sees a plan for alterations, signs it back. Seems simple enough.
Just acknowledging he's seen it, presumably.
But later, when construction starts, Hart sees the bigger scale. He checks the official council plans lodged by Finger's company. He becomes convinced his signature on those plans is a forgery.
The genesis of the whole conflict.
Right. Fueled by this, he writes those complaint letters to the council. Professional bodies accusing Silverman and Finger of forgery and deceit. Takes it public.
Which triggers the legal storm by 1988. Hart sues in Federal Court Trade Practices Act, misleading conduct. His team, Gorley as solicitor, eventually Glissan QC and Strasser as counsel.
And the counterpunch. Silverman's defamation cross-claim in the federal court, Finger's separate defamation suit in the NSW Supreme Court. Hart is now plaintiff and defendant.
A precarious position. The federal court trial date is set for May 1st, 1989. The clock is ticking.
As the trial nears, things heat up. March 1989, pre-trial conferences. Glissan QC forms a view. What was it?
He thought Hart's case was weak, especially that core forgery claim. He urged Hart to get stronger evidence for it.
Which leads them to hire the handwriting expert.
Yes, Mrs. Deanne Marsh, brought in from the U.S., a significant move, presumably costly, to try and prove the forgery. She examines the signatures and delivers her report in late April '89.
Right before the trial. And the report.
It's devastating for Hart. Mrs. Marsh concludes the signature is genuine. It's not a forgery, in her expert opinion.
Oh, wow. The absolute foundation of his case just crumbles.
Completely. And under court rules, they have to share this report with Silverman and Finger's lawyers.
So the other side now knows Hart's own expert doesn't back him up. That strengthens their hand enormously.
Hugely. In defending the main claim and pursuing their defamation actions.
But the bad news wasn't over for Hart, was it? Something else emerged around the same time.
Yes, another major problem surfaced concerning Hart's credibility. It came out that he was facing his own unrelated disciplinary proceedings brought by the Law Society of New South Wales.
In his capacity as a solicitor.
Correct. And it was serious. It had led to the NSW Supreme Court, Justice Matthews specifically, appointing a receiver to manage his legal practice.
A receiver, what does that practically mean for him?
It's drastic. It means the Law Society found issues serious enough that his practice's business affairs were essentially taken out of his hands and put under external control. And there were subpoenas out for documents related to his professional conduct issues.
So if he takes the stand in the federal court case.
Exactly. Opposing counsel would have a field day. They could use the receivership, the Law Society proceedings, the subpoenas, to just shred his credibility, attack his character, his honesty, argue he can't be trusted as a witness. It was described later as a potential trump card for the defense.
And the timing of when Glissan found out about this, that became a big argument later.
A major point of contention in the disciplinary hearing. Hart's solicitor, Kim Gorley, testified very clearly that he told Glissan about the receivership and subpoenas at a conference on Friday, April 28th. Just days before the trial.
Hart and his wife recalled mentioning it then, too.
Yes. But Glissan later claimed, in his defense, that while maybe something was mentioned in passing, he didn't grasp the full significance, how damaging it would be in cross-examination until Monday morning, May 1st, when the other side's lawyers explicitly flagged they'd use it.
So a real, he said, on the knowledge timeline.
Absolutely. But regardless of exactly when Glissan fully got it, by that Friday, April 28th, the situation looked terrible. The expert report refuted the forgery, and Hart had this massive credibility issue looming.
Glissan thought the case was hopeless by then.
The sources indicate yes. No evidence for the main claim, no expert evidence, and now a client with major credit problems. Yet, despite all this,
Hart still wanted to go ahead, still wanted his day in court on Monday.
Apparently so. Still wished to proceed, driven by that conviction, maybe desperation.
Which creates enormous tension going into that final weekend. Glissan convinced it's unwinnable and disastrous, Hart determined to fight.
Precisely. Leading us to the Sunday showdown. April 30th, 1989. The night before the trial, Glissan QC and his junior, Peter Strasser, go to the Hart home for a final conference.
Must have been incredibly tense.
You'd imagine. And then, according to the accounts, Hart asks Strasser, the junior, to leave the room.
Leaving Glissan alone with Mr. and Mrs. Hart.
Exactly, setting the scene for that critical conversation.
So what happened then, according to the Hart's testimony?
Glissan delivered a very blunt message. Challenged Hart. How in God's name did you expect me to run this case? Pointed to the lack of evidence, the expert report, and crucially, the devastating impact of the Law Society issues and receivership if Hart testified.
Painted a bleak picture of the consequence.
Extremely bleak. Warned Hart he could lose his house from the legal costs, risk his profession even further, and apparently said he just can't let Hart testify, knowing how badly he'd be attacked on the stand.
And the kicker, the ultimatum part.
According to the Harts, yes. Glissan indicated he would have to withdraw from the case, dump him as counsel on the eve of trial if Hart didn't agree to settle.
Wow. So settle on potentially bad terms, or face trial potentially alone, with a case his own QC thought was hopeless and facing ruinous cross-examination.
That's the corner Hart felt he was backed into. Mrs. Hart's testimony was powerful here. She described Glissan as absolute and emphatic. No room to move. The only option presented was settling then and there. She said her husband felt he had no choice, felt utterly cornered.
Under that immense pressure collapsing case, credibility issues, financial ruin looming, threat of his QC walking out, Hart caved.
He reluctantly agreed to settle. He changed his instructions from fight to settle, based on that pressure.
So Monday, May 1st arrives, trial day. But instead of opening statements,
Glissan is negotiating with the lawyers for Silverman and Finger.
And they reach a settlement. A deed of settlement is signed.
Yes, the case ends before it properly begins. The terms included Hart having to apologize and formally retract his forgery allegations.
A bitter pill for Hart, surely.
Definitely. In return, the defamation claims against him were likely dropped. But for Hart, who wanted vindication, the sources say he felt defeated and betrayed, forced into it.
And that feeling of betrayal, of being pressured, that's what led to the next chapter.
Exactly. In the following weeks, Hart lodges a formal complaint against Glissan QC with the NSW Bar Association, alleging unethical pressure, overbearing his will.
The Bar Association takes it seriously.
Yes. Their Professional Conduct Committee investigates and refers it to the Legal Profession Disciplinary Tribunal for a full hearing. The focus shifts from the neighbor dispute to the barrister's conduct towards his client.
Which brings us to the disciplinary hearing itself in 1990. Case number 13 of 1990. Ray Glissan. Bar Association prosecuting, Glissan defending, Sir Maurice Byers chairing the tribunal.
Right. And they heard evidence from everyone, Ray Hart, Mrs. Hart detailing the pressure, Glissan explaining his actions, Strasser and Gorley giving their versions of that crucial knowledge timeline regarding the Law Society issues. They really dissected that weekend.
And the verdict, delivered June 1991.
The tribunal found James Lindsay Glissan QC guilty. Not of the more serious professional misconduct, but of unsatisfactory professional conduct, specifically related to his actions on April 30th, May 1st. Regarding the settlement.
And the key finding, the phrase everyone remembers.
That his persistence overbore the instructions of his client. They found Hart changed his mind because of Glissan's continued pressure in conditions of extreme stress.
The penalty.
A formal reprimand. And he was ordered to pay the Bar Association's costs for the hearing. Significant for a QC, even if not suspension.
Did Glissan accept it?
No, he appealed. The case went up through the NSW Supreme Court and reportedly even got special leave to appeal to the High Court of Australia on certain legal points in late 1991.
Special leave means the High Court thought there were important issues to consider.
Yes, it's not automatic. But ultimately, despite the appeals, the sources say the finding of unsatisfactory professional conduct and the reprimand stood. They didn't overturn the tribunal's core decision.
And so, Re Glissan QC became a landmark case in Australian legal ethics.
Absolutely. A touchstone case, studied and debated ever since.
Okay, let's dig into what the tribunal actually wrestled with. They heard the different stories. How did they weigh the evidence?
Well, the core question was pretty specific. Did Glissan use improper pressure that made Hart settle against his real wishes?
Yeah.
Not just reluctance, but actual coercion that overrode his autonomy.
Hart's side was clear. He wanted to fight. Glissan gave him no choice, used absolute language, wouldn't let him testify, forced him to settle then and there.
And Mrs. Hart strongly backed that up. Her testimony about Glissan's overbearing manner, the absolute and emphatic language, the stark consequences laid out, the feeling that settling was the only option presented. The tribunal explicitly said they accepted her as truthful and that she strongly supported her husband.
What was Glissan's defense again? He didn't deny pushing for settlement?
No, he argued he urged settlement, forcefully perhaps, but out of professional duty. He genuinely believed the case was hopeless, and proceeding would ruin Hart financially and professionally, especially with credibility issues.
So he saw it as saving Hart from himself, essentially.
Pretty much. He denied intending to bulldoze Hart,
Hmm.
claimed his strong words were just explaining the dire consequences. He argued he was obliged to give that stark advice for such a weak case, and that Hart, in the end, did consent, even if reluctantly. He framed it as strong advice, client consent.
And the conflicting testimony about when Glissan knew about the Law Society receivership, how did the tribunal resolve that? Strasser saying he didn't get the significance till Monday. Gourley adamant he told Glissan on Friday.
That was tricky. The tribunal found it difficult to believe. Gourley, the solicitor, was mistaken, so they accepted Glissan was told about the receivership by Friday.
Okay, so they believed Gourley. Did that mean they thought Glissan used that knowledge strategically over the weekend?
It's subtle. While they accepted Glissan was told on Friday, they also seemed to accept Glissan's point that he might not have fully grasped its devastating tactical significance, how it would play out in cross-examination, until the other side explicitly raised it on Monday morning.
Okay. So maybe he knew about it Friday, but only realized its full power as a weapon later?
Possibly. But critically, even with that nuance about Monday morning awareness, the tribunal still accepted the Hart's account of the Sunday discussion and its coercive effect. They found Glissan's conduct on Sunday was based on appreciating the combined weight of the bad expert report and the Law Society problems, effectively using that knowledge to pressure Hart.
So regardless of precisely when he fully grasped the tactical implications, his actions on Sunday night crossed the line.
That's what the tribunal concluded. Their finding was clear. His persistence overbore the instructions. Hart didn't just calmly reconsider. He changed his mind, due to the barrister's continued pressure upon his client in conditions of extreme stress. That extreme stress context, eve of trial, shock evidence was key.
And this led to that crucial distinction they made. The finding wasn't about dishonesty.
Exactly. The tribunal went out of its way to say there was no suggestion that Mr. Glissan acted otherwise than honestly and in good faith. They believed he thought he was doing the right thing for Hart. But good faith isn't a defense if your actions improperly override the client's will. Believing you're saving your client doesn't justify coercing them. His conduct, however well-intentioned, obviously fell outside acceptable professional behavior.
Which explains the finding of unsatisfactory professional conduct rather than the more serious professional misconduct. It was a lapse in conduct, not integrity.
Precisely. Unsatisfactory professional conduct suggests falling short of the expected standard, while professional misconduct often implies something more serious, like dishonesty or a fundamental lack of fitness to practice.
Did anything else influence that finding or the penalty?
Yes, the character evidence. Glissan had support from senior judges Justice Sully, Judge Hoskins testifying to his ability and character. That likely played a role in the tribunal viewing this as a serious but perhaps isolated lapse, leading to the reprimand rather than suspension.
So the tribunal's deliberation boiled down to good intentions don't excuse coercive methods, especially under pressure. Advice, yes. Strong advice, maybe. Coercion, no. The client decides.
That's the core message, a stark reinforcement of client autonomy.
And that brings us to the legacy, right? Why is this case still talked about? Why is it a cautionary tale?
Because it crystallizes that fundamental principle. It is unsatisfactory professional conduct for a barrister to pressure his or her client in a manner that overbears the client's instructions. That specific finding is drilled into young barristers.
It highlights that tension every lawyer faces, doesn't it? The duty to be brutally honest about a case's weaknesses
Your duty of candor.
versus the duty to respect that the client ultimately gets to call the shots in their own civil case as long as it's lawful.
Exactly. Glissan had the duty to tell Hart the grim truth, but he crossed the line from persuading to compelling.
So what should he have done differently based on these principles?
Well, raise the concerns earlier, more forcefully, perhaps back in March, and certainly on Friday when the bad news landed. Present the bleak facts clearly, maybe even in writing. Give Hart time to process it away from the immediate pressure cooker.
Advise settlement strongly. Explain why, but leave the choice to Hart.
Yes, and if Glissan felt he ethically couldn't run the case to trial himself, maybe because he thought it was truly hopeless or an abusive process, though that wasn't the finding here, he should have sought to withdraw much earlier.
Not threaten it on the Sunday night.
Absolutely not. Withdrawing then leaves the client stranded. Ethical withdrawal requires giving reasonable notice so the client can find someone else or properly consider their options. Don't corner them when they're most vulnerable.
The case also showed the bar policing its own, even senior members.
Definitely. Disciplining a QC sent a powerful message. Rank doesn't grant immunity. Rules apply to everyone, silk or novice. That helps maintain public trust.
How did other lawyers react at the time?
It apparently reverberated. Lots of discussion, debate about that fine line. It really drove home the importance of client autonomy, even if you, as the lawyer, think the client's making a huge mistake objectively.
And it contrasts with other cases, like the Flower and Hart one, which was about lawyers pushing a hopeless case forward.
Right. Flower and Hart penalized lawyers for running a case with no prospects. Glissan shows the flip side. You also can't improperly pressure a client out of a case they want to run. Both define boundaries.
What happened to the players afterwards? Glissan continued practicing.
Yes, he did. And interestingly, he became quite prominent in legal education, writing books on advocacy. I have to assume this experience deeply shaped his views on ethics and the client relationship.
And Hart, did he feel vindicated by the disciplinary outcome?
The sources don't detail his later life, but one imagines seeing the tribunal affirm the principle of client autonomy, which he felt was violated, offered some measure of vindication, even if his original case didn't succeed as he'd hoped.
And the case itself lives on in ethics training.
Absolutely. That phrase, persistence overbore the instructions, is iconic in Australian legal ethics. It's a standard scenario for discussion, forcing students to grapple with that clash between advising strongly and respecting autonomy.
And the penalty, the reprimand, still significant for a QC.
Very much so. It's a public censure on your record. A reminder, as the sources suggest, of "there but for the grace of God go you." A warning that even well-intentioned actions under pressure can breach fundamental ethical lines.
Okay, so summing up the big takeaway from this deep dive into Glissan QC.
It's the absolute centrality of client autonomy in the barrister-client relationship. Your job is to advise, guide, persuade with reason, but never, ever coerce, especially under pressure.
The decision rests with the client.
Period. Even if you're convinced they're wrong.
And this story, it really shines a light on power dynamics in any professional relationship, doesn't it? When someone relies on your expertise in a high-stakes moment.
Absolutely. Whether you're the client trusting an expert or you're the professional giving advice, it forces you to think about that responsibility. How do you guide effectively without overwhelming or improperly influencing the person relying on you?
It leads to that final, maybe provocative thought. This case wasn't really about winning or losing the original lawsuit, or even about Glissan being dishonest.
No, the tribunal accepted his good faith. It was purely about how he treated his client in that moment of crisis.
So does the intense pressure of big litigation, the genuine belief you're acting in the client's best interest to avoid ruin, does that give you a pass to bend the rules of engagement with your own client?
Or is it precisely when the pressure is highest, when the client is most vulnerable, that those ethical principles respecting their autonomy, avoiding coercion, become the most critical things to uphold, even if it feels counterintuitive?
Looking at what happened, the pressure Glissan was under, the state Hart was in, what would you, listening, have done in Glissan's shoes that Sunday night? It's a tough question.
It really is, and it's one every legal professional needs to consider deeply.